It's day 6 and the final day, of the Sarah Boone trial. We should be getting to closing arguments today. This morning is going to start with the jury instruction conference. They're not going to finish it because we're going to have to do more jury instructions, because the big fight in jury instructions is going to be over that self-defense instruction we heard them talking about yesterday. But the state only has text messages left to admit. I don't think we're going to end up getting any rebuttal from the defense. It would be unusual if we did. The jury charging conference actually went fairly smoothly. There was some argument on points of law for some of the instructions, but at the end of the day, much was agreed upon. The defense made some arguments and the judge was like, anything else? And he's like, no. No, nothing else, because those are instructions that are coming in. So we're going to see instructions on battered spouse syndrome as it applies to reasonableness in the perception of fear for self-defense. We're going to see those self-defense instructions. We're going to see instructions about whether or not Sarah Boone was the initial aggressor. And if she is the initial aggressor, then they can discount self-defense entirely. I expect that we will hear the attorneys explaining some of those key jury instructions during their closing arguments. But if they don't, I think it is a failure. I said that in the Karen Reed case that I thought both sides not really explaining the jury instructions was a failure on both of their parts. They only had an hour to close. I think they should have pushed back on it in that case, because explaining the jury instructions to the jury is critical. And I love it when attorneys go through the elements and say, this is how you know we've proven this. You're going to be asked to decide this. And we saw in opening that Owens wanted to bring in giant poster boards of jury instructions and say, hey, this is the instruction. And the court's like, this is not argument. So the poster boards, I think, will be back. And I think we'll see the defense going through that. The prosecution should too. Explaining to the jury what the instructions are, I think, is critical, because how else do they know how to work through that? Jury instructions can be difficult. They can be lengthy. So going through them is necessary. And we are at the end of the state versus Sarah Boone, the end of a very long day 6. The jury got excused at about 7 o'clock local time in Florida to begin their, dinner and deliberations. After closing arguments, I think, the poll in the chat has said that the prosecution was more persuasive, over 97%, with, at this time, over 7,000 votes in the live stream chat. The prosecution gave a closing argument to narrow down the jury focus, telling them which jury instructions they could discount entirely, which jury instructions to focus on, and reminding the jury that what happened on this day is what they need to focus on. Was Sarah the one provoking George Torres? Was Sarah the one that was going after him that day? Sarah zipped him into the suitcase and left him there. In the very beginning of opening statement, the prosecution brought out the suitcase, put it on the floor, and said, this is a box, and then went through that this is the box where George Torres was murdered, and went through the videos, went through some of the more difficult videos. And at one point, Torres's family member had to leave the courtroom because of that video. Later, the defense objected and said there should be a mistrial based on that family member having to be excused. The court denied that as quickly as I've seen him deny anything in this case. Then we got to the defense's closing argument, where it seemed that Owens was going with, I'm just a simple country lawyer, and said repeatedly to the jury, I might not get this right, but I hope that I did, almost leaning on them to pick his side and to fill in the gaps of his argument. I think he could have used the jury instructions more to his advantage, but he did say that the reason you don't see videos of George Torres being aggressive towards Sarah is because he didn't do things while she was filming. But then in rebuttal, the prosecution said, yes, but then they're playing clips saying he's supposedly violent in these clips that they're showing that are edited down. I think the rebuttal was helpful. I think the prosecution's closing was much more linear. The defense had moments, but will those moments resonate with the jury because of how lost they got in the defense getting lost in their own closing? It was not as smooth and linear. even though he said things like Sarah Boone was acting out of a brain that was changed by trauma and was trying to explain battered spouse. But then he also went a pretty far way to say that George Torres was a monster. So will that be persuasive to the jury, and will they be back tonight? I guess we will see.
You've come to a verdict in this case.
Yes.
If you could please hand the
yes.
verdict form to the deputy, please.
I imagine he'll poll this jury. Did you hear numerous voices say yes?
Thank you, sir.
The court
Madam Clerk,
will
if you could
review,
please publish the verdict.
and she's going to read it right now.
In the Circuit Court of the 9th Judicial Circuit in Orange County, Florida, case number 2020 CF 2603, the state of Florida versus Sarah Boone. Verdict. We, the jury, find the defendant guilty of murder in the second degree.
Guilty, count one.
As charged in the information.
And that's that.
So say we all, dated at Orlando, Orange County, Florida, on this 25th day of October 2024. The form has been signed by the foreperson.
Sarah
Madam
Boone,
Clerk,
guilty,
please
count
poll
one.
our jury.
And now they'll be
Juror
polled.
seat number 1, is this your true and correct verdict?
Yes, it is.
Juror seat number 2, is this your true and correct verdict?
Yes, it is.
Juror seat number 3, is this your true and
Yes, it
correct
is.
verdict? Juror seat number 4, is this your true and correct verdict?
Yes.
Juror seat number 5, is this your true and correct verdict?
Yes.
Juror seat number 6, is this your true and correct verdict?
Yes, ma'am.
That
Members of
juror
our jury,
was
again,
pissed.
I want to thank you
Did
for
you
your
hear
time,
him?
your sacrifice,
Woo!
and your attention in this matter.
So late on trial day 6 of Florida versus Sarah Boone, the jury came back in about an hour and 30 minutes, a little under that, with a guilty verdict on the only count she was charged with, second degree murder. The jury was polled. They swiftly acknowledged that that was their verdict with some amount of force in the polling. They're like, yes, it is our verdict. And I think the swiftness of their verdict told us that. We also saw some interviews after court with attorney James Owen, who gave actually a pretty restrained interview saying that he thought that Sarah Boone really sees this case as that her intent was never to kill George Torres, and that for that reason, he didn't see her ever taking a plea deal. He confirmed that he would not be representing her on appeal. She's been convicted. She has the right to appeal. The sentencing date's been set for December 2nd at 1:30 in the afternoon Eastern. And at that time, we will see some victim impact statements, possibly a statement from Sarah Boone. She has the right to, possibly a statement from one of her appointed experts, and likely statements about this case from the judge, and find out her sentencing at that time. She is facing 22 and a half years at the minimum, up to life. So the judge is going to have time to evaluate this. They're going to do a pre-sentencing investigation that's done by the Department of Corrections or the probation department, depending on how they operate it in Florida. They will do an entire workup of this case, the facts of the case, input from the victim's children, the victim's family, input from medical professionals, input from Sarah Boone, and go from there. And then the prosecution will make a sentencing recommendation either in motion or verbally in court. And the defense will probably ask for 22 and a half years. So that is what is going to happen coming up on December 2nd, 2024. But after a long day, that jury was not going to go over the weekend deliberating this case. And I think that shows you what they thought of the evidence in this case and the defense in this case. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.